Hello, it's Georgia Trial Attorney Jack Clay. Today I'd like to talk to you about the trial process in the Georgia state court system and what happens. A lot of people ask me the question of, well, we're going to court, what should I expect and what's going to happen at my trial? Well, trials are not that frequent, but when they come up, there's a lot of things that people need to know out there, whether you're an attorney who's handling cases looking for tips or you're a client with a case. Thanks for joining me. First, there are a series of events immediately leading up to trial. What takes place when you go to court for your trial is typically the judge will hear what we call motions in limine, which are decisions the judge has to make regarding admissibility of certain things. We try to keep out certain things and get in certain things into evidence beforehand so everybody's clear about what will happen. The other thing that typically happens during this time is we gather our exhibits and witnesses and we make sure that we have a clear trial plan. Second, voir dire is the process of choosing a jury and it kicks off the trial. When you walk into a courtroom, whether you have a personal injury case, a contracts case, a business dispute, or what have you, the attorneys will have to pick a jury with your help. What happens is you'll typically see between 15 and 35 jurors, depending on the kind of case you have, all lined up for questioning. And what happens is they need to be questioned about their biases and prejudices so you can ensure that you receive a fair trial. Third, opening statements. Opening statements is the beginning and the first time for you and your attorney more particularly to set the stage, to get the trial going, in other words. What you're going to talk about is things that you expect to prove and what you expect to show the jury in the case. You want to present a clear and accurate picture of what they're going to see so you can follow the old adage of tell them what you saw, and then tell them what you saw. Fourth, the plaintiff puts on their side of the case. This is the time for you and your attorney to present witnesses and documents if you're the plaintiff. A trial is really made up of three things in my opinion: witnesses, documents, and then a theme of the case. Fifth, the defendant puts on their side of the case. Typically in my cases I represent plaintiffs. However, some folks out there who we represent are defendants in a contract dispute, a business dispute, or some other type of case. When this happens, the defendant is up there, and if you're on the other side, you need to be sure that you've given your attorney all the information they need. And attorneys out there, you really need to be sure that you're able and capable of cross-examining the other side appropriately so you can put holes in their case when necessary. Sixth, closing arguments. This is the time to shine in a lot of attorneys' eyes. You get to stand up as an attorney and argue your case to the jury. Clients, this is where many cases are won and lost, in my opinion. I believe that most cases are decided by jurors either in the front end during voir dire and opening statements or at the end when they can be swayed to some degree during closing arguments. There are many different opinions about that point, but I believe a strong closing is important to your case. And finally, the decision. This is the time in which the jury comes back and renders a verdict either in favor of the plaintiff or the defendant and typically awards a certain amount of money. If you, a friend, or a loved one needs an attorney that has experience in the trial process and you would like to have an attorney who honestly answers your questions, we're here to help you. We're conveniently located across the street from the Douglas County Courthouse, where we have handled hundreds of serious litigation cases over the many years in which we've been in practice. Thank you for joining me.